Hi, my name is Stephani Prieto, and I'm an attorney at the Nieves Law Firm, and today we're going to talk about domestic violence charges and domestic violence restraining orders and what the difference is between those two. The biggest takeaway today is that domestic violence charges are criminal in nature, whereas domestic violence restraining orders are civil in nature. And there are three major differences that I want to highlight today. The first difference is going to be who can bring forward domestic violence charges and who can bring forward a DVRO request, also referred to as a domestic violence restraining order. Additionally, I'm going to talk about the difference in timing that both of these matters have. And then lastly, we're going to talk about the standard of proof in each of these cases or matters when they're brought forth to the court. Now let's shift into who can bring forward either domestic violence charges or a domestic violence restraining order. A domestic violence charge can be brought forth by the district attorney. They are the ones that will press the charges against whoever the defendant is and file a criminal complaint for domestic violence charges. They are the ones that are tasked with proving every element of the crime that they charged. While the victim might play an important part in the case, they're not the ones in charge of presenting evidence. They're not the ones in charge of proving that they've met every element of the crime. That falls exclusively on the prosecutor. When you compare that to DVROs, in DVROs, either you or an attorney on your behalf can request for this civil restraining order. Now, because it's you or your attorney filing for a domestic violence restraining order, the burden of proof of showing the judge that there is a case and you need this order falls on you or your attorney. Now let's shift into talking about the timing for these matters. The timing for domestic violence charges can vary greatly. They can resolve very quickly by entering a plea or reaching a negotiated deal, or they can take a while where they might be set for a hearing and they might go forth to trial and there's additional investigation to be had that can really delay things on the criminal side. Now, the timing in restraining orders for domestic violence, they are given a statutory priority, and that means that they should be heard within 21 days. Now, that doesn't mean that they always will be heard within 21 days, but for the most part, it can be that quick. And the purpose of it is 21 days because you need this urgent order for your protection. Lastly, let's talk about the standard of proof in both of these matters. For domestic violence charges, the DA has to prove every element of the crime beyond a reasonable doubt. Now, that is a very high standard. When you compare that to DVROs, DVROs require a showing of proof by a preponderance of the evidence. And that means that you only have to show over a 50% chance that your claim is true. That means that you can show by 51% that your claim is true. That is the lowest standard of proof, and it's often used in many civil court litigations. If you are facing domestic violence charges or have questions, or additionally, if you just have questions about DVROs and the standards and whether your case would qualify for domestic violence restraining order action, please feel free to contact the Nieves Law Firm, and we are ready and willing to help you.